Welcome to our program today. It's titled How Your Nonprofit Can Operate a Legally Sound Certification or Accreditation Program. As I say, I'm George. I work here in the nonprofit practice group of Venable. I'd like to welcome everyone here who's here in person. We got about 100 folks who registered to come in person, and happy to have everyone here. We also have about 250 people on the phone, so welcome to all of you as well. And this is part of our monthly series that we have on nonprofit legal issues, and I'll talk a little bit about a couple programs we have coming up. Each of these programs that we have are actually available. We have a YouTube channel where they're available. The recordings are available. They're not video, just audio recorded. So they will be up there, and the address of how to find that will be on the last slide of this PowerPoint presentation. That also includes a link to our collection of some 750 plus articles on nonprofit legal issues. So please feel free to avail yourself of those. We're really excited about this topic. We have some great panelists who can talk about their experiences in the certification and accreditation world from a first-hand basis. From my perspective, we do a lot of work representing organizations that operate these programs, and as you might imagine, there are a lot of different legal issues that can arise with these programs that come into play, and we'll talk a little bit about those as you know, for the next hour and a half or so. We definitely encourage you to ask questions as they come up. You know, the panelists are ready and ready to answer, and we want to make sure we hit the issues that you guys want us to talk about, so feel free to ask questions. One thing I'll ask and remind the panelists too, we'll wait for a microphone to be brought to you so the recording can pick it up and so the people on the phone can hear that. And for those on the phone, there's the chat function where I'll monitor to make sure we address your questions as well. Just a few housekeeping items before we go forward. For those of you in the trade association professional society community who may have the CAE designation or interest in obtaining the CAE designation, these programs, including this one, are eligible for CAE continuing professional education credit. Also, here are our upcoming programs, just for those of you who may be interested. November 10th, we have a great program scheduled for addressing federal and state regulators and their focus on charities and professional fundraisers, and we have some really good panelists to speak on that topic on November 10th. And then we've got an international topic on December 12th, top 10 risks facing nonprofits operating internationally, and that's co-sponsored not just by us, but by BDO as well. For those of you in the room, you have a printed handout book that contains a slide deck for today's program, along with the full bios of our speakers. Those of you on the webinar should receive the link to the slide deck as part of your confirmation email, and tomorrow you'll all receive an email containing a link to the recording of today's program, along with the slide deck and all of the handout materials. As I said, we'll be taking questions throughout the program. So the way we're going to work this is I'll give a little bit of background, a little bit of overview before turning it over to Bill and Julie. Before doing that, I'm going to introduce both of them now, and then we'll get started. So to my far right is Bill Scarborough. He's General Counsel of Project Management Institute. He has, prior to coming to PMI, he had served in private practice for 18 years. His area of practice is primarily focused on trade association, professional society law, and as you'll find out, PMI has a tremendous certification program. I'm sure many of you have heard of the PMT designation, but it's very popular, perhaps one of the most popular certifications that a private association can offer. Bill's a member of ABA, American Bar Association, Association of Corporate Counsel, and ASAE, where he served as chair of the Ethics Committee of ASE and has served on the ASE Legal Section Council as well. Bill's a member of the American National Standards Institute ANSI Committee on Intellectual Property Rights. And one last point, very recently, Bill was named, his office is in the Philadelphia area, the Philadelphia Business Journal named Bill the Outstanding Corporate Counsel of the Year, so congratulations on that. Well deserved. My immediate right is Julie Hart. She's Senior Director of Standards and Excellence Programs for the American Alliance of Museums. Julie's worked at AAM for 20 years. In her role, she provides the overall strategic and administrative direction and vision for a number of programs and activities that AAM operates, including the Accreditation program that she'll talk about today, Museum Assessment Program, Peer Review, Standards and Ethics, and a number of other programs that AAM offers. And one of Julie's roles that she'll play for AAM, sort of outside of the operation of these programs, is providing guidance internationally to other either governments or private entities that want to embark upon an accreditation program for museums. So AAM's program is truly a model for others outside of the U.S. So welcome and thank you for joining us.
Add one thing. I just want to also add to the bio that I'm part of the Maryland Nonprofit Standards for Excellence Institute. I'm on their ethics standards committee as part of their accreditation program.
Oh, great. Very qualified. I feel a little humbled by it. So we're going to talk a little bit about some of the legal background of accreditation and certification programs, and then we'll go into the case studies and experiences that both Bill and Julie have had, and those will sort of bring up some of the legal issues and other practical issues that come into play with operating these programs. Again, questions as they come, please. So just this very basic background, it's quite common for particularly trade associations and professional societies to offer certification and accreditation program. When we're talking about certification today, we'll be talking largely about certification of individuals, people who meet some standard, who pass some test, or who have some experience or combinations of those things, and therefore get the ability to put some designation after their name, be it PMP, whatever the acronym might be. But also a lot of these issues we'll touch on certification of products as well. Curious if anyone in the room are from associations that have a product certification program. Okay, we got one hand, two hands. So, and in the room, how many certification of individuals that you're coming from organizations that do that? And that's a pretty large group for those of you on the phone. In addition to certification, obviously we're going to talk about accreditation, and there's no sort of legal import to these terms, but they've come to be known. Certification more on the individual and product side, accreditation more on sort of the entity side, whether the entity has met some standard and has shown to be effective and able to carry its own designation, be it an acronym or some other name that they can use in their advertising and their marketing to show their effectiveness. There we go. So from a legal perspective, there are a number of legal issues that come into play with operating these programs. Due process, antitrust, ADA compliance, intellectual property issues, both copyright, trademark, and even patent come into play with some of these particularly technical standards that may be set, in tax-exempt status, as well as some tort liability issues. I'm going to touch the very surface of each of those real quickly just so we all have a bit of a grounding. There's a good handout in your book that talks a little bit more in depth of some of these legal issues, which I commend you to take a look at. And as we go through each of Bill's and Julie's presentations, we'll get into more detail on some of those issues. I will say when I talk about certification and accreditation, when we're talking about here, there's really two aspects to both certification and accreditation from a practical perspective. The first thing is there's a standard that's set. You have to set a standard that before you measure whether someone is able to be certified or is able to be accredited. So that in and of itself is an activity that carries with it some legal risk, oftentimes in the antitrust category, but in some of these other categories as well. And then once you have the standard, you're testing people, you're testing products, or you're gauging effectiveness of organizations, plants, whatever it might be. You have a process in place there. And then sort of the implementation of your certification and the implementation of your accreditation is the second aspect to it. So it's really two activities under these programs where you can come into some of these legal risks. So we'll start very briefly again. I'm going to touch on the surface of these and really want to turn it over to Bill and Julie to get into some of the practical examples of how their programs operate and how they manage their risks. From a due process and antitrust standpoint, particularly on the standard setting side of things, there are no shortage of antitrust cases over the years that involve standard setting activities and the implementation of those standards to perhaps exclude one or more competitors that lo and behold may be ones that charge lower price or that may be making inroads into the industry or the profession. A lot of the classic Supreme Court antitrust cases involving associations, like the Hydro level case that many of you may be familiar with, involve just that, where you have a association that has a standard setting process and makes a determination that the standard should be at this level to keep out particular types of products that are nonetheless effective and do what the standard is supposed to measure, but also are cheaper. Where the standard itself is designed to keep out competitors and has no other pro-competitive value, you can have significant antitrust risk on that front. Not to get too in the weeds on the legal issues, but courts, when they analyze antitrust issues, they try to determine whether the particular activity should be analyzed under per se illegal review, such as a price-fixing activity, or under the rule of reason, which allows an organization that's under the microscope to show the pro-competitive benefits of their activity. Standard setting usually fits under that better rule of reason category. So what an organization that's ever under the focus of an FTC or a DOJ on the antitrust side of things would be able to show is we are, for instance, improving safety in the industry, or we are improving efficiency because we are standardizing the means with which this product or this activity may be engaged in. But someone who is denied certification, who's denied accreditation, will very often, when there is a legal case, they will very often try the antitrust route and say, well, you weren't denying me because I was bad, or you weren't denying my product because it was bad. You were actually trying to keep us out because you wanted to keep the market small. So when we talk about some of the risk management protections that can come into play to guard against that, obviously setting a standard that's fair, that's open, you go through a process, and this is where due process comes into play, that you include all the possible parties that could be interested in the standard as part of your standard setting process to make sure it's an open process, give people the opportunity to criticize, complain, and suggest different ways to get at your standards measurement. Make sure that the committee that's deciding whether a standard is going to be recommended or not be one that's balanced, includes all aspects of a particular industry or profession. Obviously, from a due process standpoint, you want to manage your record keeping well. You want to make sure that you document all the good steps that you take, and you may consider on that allowing one or more aggrieved parties to appeal a standard decision that they feel is not fair or doesn't measure accurately what the standard purports to measure. There are some protections from the Antitrust Liability. There's a Standards Development Organizations Act that was passed in about 10 years ago that allows an organization that goes through this fair process that I just laid out to remove itself from certain antitrust liability risk. Largely, it removes your risk from treble damages, for instance, which is often what's available to an antitrust plaintiff if they're successful. So it's not just in the standard setting process, but also in the actual implementation of the certification and accreditation. And both Julie and Bill will talk a lot about their processes for how you go about obtaining certification for their organizations. And there's fairness built into those processes for good reason. We need to, as organizations that give the ability for someone to use an acronym after their name, which helps them get jobs, which helps them keep jobs or advance in their careers, we have an obligation as an organization to do that in a fair way that doesn't unnecessarily or unfairly cause those people to lose that designation, cause those people to suffer harm from not being able to be promoted, not being able to get that next job. The fair processes would include the ability to petition for perhaps like a recount of the examination if it's a certification, or perhaps petition for a new peer review if it's an accreditation process, and it's just some right to contest decisions so that the individuals or the organizations that are harmed cannot say that they were unfairly treated. I think due process also carries with it an obvious need to treat like organizations in the same way. So oftentimes you'll have a standard, and if it's not implemented fairly across all potential accredited entities or potential certificates, you will have risk under the due process theory. And I would say also that these processes are very important, not just from a strict legal keep you out of court perspective, but particularly in the certification realm. There are organizations like NCCA that will accredit your certification activities and make sure that your processes are fair and impartial. And for many organizations, it's very important to have that accreditation, and that gives a bit of a stamp of approval to your activity. And to be able to meet those standards and convince the auditors who work for these organizations that you're doing it right, you've got to show these processes are in place and are fairly applied. ADA compliance, we could spend a whole session on the ADA implications on certification activities because it's created quite a body of law since the enactment of the Americans with Disabilities Act. I would say, suffice to say now, given our time constraints and our desire to get to some of the other topics that we're going to talk about, very often you will, if you administer examinations for your certification program, very often, and I know Bill's no stranger to this, you will get requests for accommodations from people with disabilities, and you need to listen to those and accommodate those where reasonable. There are certain standards that apply that give the organization some rights, such as it can't constitute an undue burden for the organization, but you need to have a process in place and again, a fair application of that process so that for those who come with the same disability have the same response from your organization. Just a couple of points on this before moving on. Very often the request, I would say, correct me if I'm wrong, Bill, but very frequently the request involves some type of extension of time or the ability to take the exam in pieces as opposed to all at once and those sorts of things. And it's just important to note that a learning disability is considered a disability on the Americans with Disabilities Act. So things like ADHD and those sorts of things can cause you to be required to make accommodations. Just another point that those of you who deal with the ADA probably know full well. As an organization, you can't charge the individual for the accommodation you're making. You can't charge them extra. That needs to be an expense borne by the organization. Another point, in addition to that you have the ability to push back on a requested accommodation that might cause an undue burden. There's another standard that has come out in the case law with regard to the Americans with Disabilities Act is the accommodation cannot fundamentally alter what it is you're measuring. So, for example, if someone is requesting an accommodation to a certification exam that measures competency in an engineering field and claims a learning disability, that doesn't mean that as an organization you need to lower the standard and lower what proficiency that person needs to develop. All that you are obligated to do is change the manner with which you measure it in a reasonable way so that you're still measuring to the same standard. You're not lowering your standard for that person, but you're measuring it in a different way. Lastly, it's not necessary to necessarily accommodate the specific request that the person makes. So if a person says, I have this disability, therefore I am requiring you to double the time available for me to take this exam. If there's another way to accommodate that disability that the organization feels would more fairly and accurately measure proficiency or competency in a particular field, particularly if it's one that the organization has used before, then the organization can go with that one. It doesn't have to immediately go to the one that's requested by the individual.
I would just say to George, if I could. There we go. I think one thing that's really important about dealing with disabilities is that you learn about it as soon as you can. So build into the application system when they first apply, there ought to be a provision in there for them to tell you if they're going to declare a disability, so you can start dealing with it at that early phase of the application. If you have it at the back end, it just creates all sorts of problems of scheduling and who said what and what they did and what's going to happen. But if you have it up front, then you can deal with it more effectively.
Thanks. That's a great point. IP, and I think on Bill's slides there's a lot of discussion on there's both copyright protection issues. You're setting a standard. You're using questions. You're creating a set of policies and other documents that may be affiliated with your accreditation program. All of those sorts of documents generally are subject to copyright protection. There's one area that's in a sort of questionable mode is if those standards are actually adopted by a governmental body. You may be pushing your copyrighted materials into public domain realm because it's government adopted. That's an area of hot dispute in terms of litigation, so it's not something that's well settled. But for most of us who engage in private certification of individuals or private accreditation of entities, those documents that go along with that obviously have and then should be protected as any other copyrighted materials. And obviously we'll talk a little bit about one of the big concerns that individual certification bodies have had over the years. Not as just protecting your copyright, but guarding against these questions being disclosed publicly on the internet from test takers and the like. It's become a real problem with certification programs, and there's some policing mechanisms that you can undertake. But obviously, maintaining your copyright ownership gives you some legal arrows in your quiver if you need to fight that. And similarly, if someone's going to use your name, your program's name to say, hey, my museum, my facility is accredited and it bears the AAM accreditation, or it bears I'm an individual, I get the PMP designation. Well, obviously you have trademark rights in those names, and you need to protect that. And again, just as we have these ne'er-do-wells who will take and disclose confidential exam questions, you also have people who seem to have no problem with saying they have this certification or they have this accreditation when they really don't. And another piece of ammunition, if you need to fight that, is to have that trademark registration in place and you've locked it in. Tax exemption, real quick. This is an issue that comes up whenever we talk about certification in particular. Certification activities in the eyes of the IRS generally are consistent with 501c6 membership organization status. Generally, the IRS takes a dim view of certification activities being conducted by 501c3 organizations, with the theory being, with the last ruling that the IRS has sort of squarely ruled on this issue, the theory being that an individual who is seeking certification is generally doing that primarily or substantially for the benefit of his or her individual career. While a certification program is clearly, I would say, ancillary to an educational mission of a 501c3 organization, yes, we engage in education. We educate individuals, and here's one way we measure it is by testing them. The IRS has said that may be one aspect of why you do it, but another aspect is to help people advance in their careers, and that sort of activity and that sort of purpose is more suited for 501c6 than 501c3. It's an area that comes up from time to time. Certification of individuals, largely 501c6. Accreditation programs are a little different. The IRS has many rulings involving accreditation programs where the entity providing the accreditation is a 501c3 organization. Usually then what the IRS focus will be is who are being accredited and what is the sort of the audience and purpose of it. So, I mean, a great example is museums, where sort of the advancement of the arts is a clear 501c3 purpose. And if we're in the business of accrediting other museums that are clearly nonprofit 501c3s themselves and in the business of advancing the arts, that sort of program will pass muster under 501c3 as well as 501c6. Education, health, there's a lot of organizations that accredit healthcare facilities, for example, that are 501c3 perfectly fine. And then lastly, again, very briefly, I call it tort liability. What if a third party is harmed by a company, facility that your organization accredited? Don't you have some obligation as the body that issued that accreditation, as the body who gave that designation, to ensure that the persons who are the end users of the products or services of those accredited bodies aren't you obligated to sort of be on the hook for the damages that are caused there? And here the courts are split, and the general rule has been favorable for accrediting bodies and organizations that are engaged in standard setting, that usually standard setting bodies are viewed as having no duty to an end user, that our duty is only to our contractor, the person who is receiving the accreditation, who is sitting for the certification, but not to the end user of the product or service. But there are ample examples where that has not been the case in some very high-profile cases. Probably the most familiar one involves the National Spa and Pool Institute from some 20 years ago, where the organization had set a standard for the depth of pools that can have diving boards, and there was a really horrible situation involving a quadriplegic who sued the organization for negligent standard setting in Washington State and was successful, and that was upheld. So there are reasons to be aware, I won't say scared, but be aware of the fact that when you set standards, particularly in the safety arena in areas where there's some foreseeable harm if the standards aren't met, that you do so very carefully and in a way that goes about a set process that has all of the hallmarks of due process that I said at one of the earlier slides, and you manage the standard setting process in a way that you can say you were not negligent in how you did that, and ultimately that will be sort of a second defense in addition to the no duty to end users defense. Also, the marketing language that you use when you talk about how great your certification is and how great your accreditation is, it's a little counterintuitive, and the marketing people and the lawyers seldom get along. The more sort of great the accreditation looks, the more spectacular the certification program looks to the third parties. The worse the facts are on a case involving a harm that may have been caused by a certified individual. The marketing language should stick to what we're actually measuring. We're not guaranteeing that a person, is mistake-free, or that a person is, necessarily going to guarantee against harm or injury, but rather we're measuring competency in a particular profession or field, or we're measuring compliance to a standard. The last point is defamation. Sometimes these cases can arise in the defamation context, particularly in the individual. You can have defamation against an entity or a product as well, but where an individual is refused certification, or perhaps oftentimes having it removed because of some ethical issue or something like that, they may bring cases against the organization on the theory that they were defamed. Now, there is a good sort of qualified privilege that applies to standard setting and certification bodies in particular, that if you go about a fair process and you have perhaps a committee discussion or a board discussion about particular issues, it creates a much higher hurdle for the individual to claim that defamation liability occurs. It essentially puts it into that actual malice standard that happens for public figures in most states that have this qualified privilege or immunity. So still, what it argues for is maintaining the confidentiality of your deliberations, particularly if it involves areas that have to do with the ethics of the individual who may be under question, and not to let out any statement or implication with regard to that individual other than pursuant to your process that you have in place, and you feel you followed your process and you've gone through a fair analysis of that person's competency or that person's ethical behavior. Then and only then should that disclosure happen. So those are some of the sort of high-level legal background issues, and we really want to get into the more specifics that we've got with some great two panelists here at the table. So we're going to start with Bill and to talk about PMI. And again, I encourage you, as questions come up, to let us know. So over to you, and pass this along.
Thank you, George. A little bit of background before I get into the actual certification piece of it. Project Management Institute is a professional membership association for basically anyone interested in project management. We don't have any tight criteria for joining PMI, and as of now, we have about 500,000 members in about 183 countries. We also have our standards program. You don't have to be a PMI member to be certified by PMI. So you'll see globally we have about 800,000 people certified. About 46% of those are in North America, and the remainder are pretty well dispersed throughout the other continents. Our first certification was created in 1988, which was the Project Management Professional, PMP, which is our flagship standard, or certification rather, today. We now have 8 certifications. Interesting how that certification was begun. The board of directors back in the mid-1980s said, you know, we really need to start promoting the project management as not a set of skills, but as a profession. And so what we're going to do is we're going to create a profession. And how they determined to do that was they said every profession needs a standard, every profession needs a certification, and every profession needs a code of conduct, ethical code of conduct. And so that's where it all began. And all of those are very, very well linked. We have our project management body of knowledge, PMBOK guide, which is a good, popular manual amongst people trying to learn project management. It's usually in the Amazon top 100 business books every year. We do some use of that in our certification, but we don't say our standard is the only thing that we certify against, because the aim of the certification is to determine or delineates a person's ability to act as a project manager. And there's more to it than a body of knowledge. There are other competencies involved. So we try to be as broad and as objective as we can be. So every several years we have a professional organization come in and do what's called a role delineation study. And what this organization does is will answer the question, what do project managers need to know to be project managers? And what is the emphasis of the types of tasks they do to do project management? Some of it may be in our standard, our PMBOK guide, but there are other parts of the role that maybe aren't. So what this organization does is creates this role delineation study for us. That role delineation study is then the basis upon which questions are developed. And those questions are developed in what we call item writing sessions, which are global in nature. Around the world, people, project management professionals come in and spend a day, 2 days, talking to the development team about their war stories, what came up in their job, developing questions that then are funneled back into the system and evaluated for purposes of putting them in the examination. So it's a pretty extensive project to come up with the 200 some odd questions that form the examination. The exam itself takes about 4 hours to take. Some of them are proctored paper-based exams when there's a sufficient bulk of people who can come together and take it at one time to make it, efficient to give that kind of paper-based exam, with a person obviously proctoring the exam to make sure that none of the test exam portfolio goes out the door with anybody. There are other comical war stories, like people saying, I have to go to the restroom, and they're in the restroom, and the proctor says, taking too long. And you go in, and by God, there they are with their books in the stall, But anyway, so those proctors kind of paper-based exams do take place. But the more typical and the more efficient way of doing it is we have an outside exam given Prometric that has test exam facilities all around the world. And those exam facilities are very secure. No one can download the exam off of the computer they're taking it on. The exam itself is housed in the Prometric servers at their corporate center. It also gives us the ability of having a lot of different, not a lot, but different questions. So if two people are sitting next to each other in the exam center on a computer, that one and that one may not have the exact same questions. And it reminds me of Mr. Bean, if you saw that one, where he's sitting there taking the exam, and the whole comedy's around him trying to look over and flopping pencils to see what the exam questions are. And then at the end of the story, it says, individuals with odd numbers pass your exam to the right, individuals with even numbers pass your exam to the left. And then he finally realized that two people on either side of him had different questions that he was writing down the answers to. But it does happen. So with the computer-based testing, it's a lot more secure. It's also good because the computer does the grading. So there's an almost instantaneous grading going on that doesn't happen when it's a paper-based and you have to manually go through the exam. Another thing too, and we give our exams in 14 languages throughout the world. One thing to, if you're thinking of going global with a certification, remember the OFAC, the Office of I'm going to lose it now. Foreign Asset Control. Yeah, regulations. They apply to not just passing goods overseas, but also providing services and education. So in terms of where you can give your exams and to whom you can give your exams, you need to look at the OFAC regulations in that regard. Some of the legal issues that we see, and maybe they could become even more. Before I go into this, I want to also say, in terms of trying to have an objective and an appropriate certification process, we also plan our process based on the ISO standard 17024, which is on certification of persons. And we are actually accredited by the American National Standards Institute, which is the ISO affiliate in the U.S. We are accredited by them, and they come in and audit us on an occasional basis we're accredited as being compliant with ISO 17024. So there again, it's another way of ensuring in terms of risk that your certification process is being compliant with best practices. Back to the question of legal issues. A few things that I see and I deal with, and the more successful we are, I see them more rather than less, for obvious reasons. PMI made a decision some time ago that in order to be the objective certifier, we should not be doing the training for the exam. So we do not train for people taking our certification examinations. The consequence of that is there's an industry's grown up of people, of trainers who are training people to take our exams. And some of the issues that come up with that, particularly in the advertising, is claims that they have 100% pass rate for people who have taken their training, that they have access to the real test questions, and some of them then set up their, some of the training companies set up their own, what they call certifications, which is basically, I call a certificate, which is a issue right there, right? What's the proper term to use? Where if you take the course, a course, and they give you a certificate, and then you're certified. So that's something we've seen, and I'll get to how we deal with these in a few minutes. And then individual test takers. Well, I should also put in there individual non-test takers. There are those who claim to be certified by us that have never walked through the door. And another issue, of course, is people taking the exam, trying to memorize as many questions as they can, and then using those questions to go back to training companies or whatever, or passing them on online or what have you. So there's some of the things that we deal with every day. Okay. So one thing we do is we copyright our tests, and that's a process that's relatively easy. We have a person who comes down when we change the test enough, and we say it's time to register a new copyright. A person comes down from Philadelphia, having arranged a meeting with the Copyright Office, brings a sample, one of our tests down. The test is then converted into what is called a secure copy. And a secure copy of the test is so that obviously if that test is on file with the Copyright Office, somebody might read the test. But the Copyright Office has its own process where you can have a secure copy filed with them. And what a secure copy kind of looks like is a copy of think of a page of the test, and you put a very fine screen on the front of it. So you're seeing various letters of words that are actually in the page, but you can't read the exam because there are too many words screened out of it. And so that's what goes on file with the Copyright Office, that secured copy. And so that is one way we try to protect our examinations from people or companies that are trying to take our questions. It's a breach of copyright to obviously to do that. Another thing that we do as well is as part of the application process, the individual going to take the examination signs an agreement with us. And that agreement has a number of clauses in it. One is to abide by the PMI Code of Ethics and Professional Conduct. And another is to agree to maintain the confidentiality of the exam question. And there's also an indemnification provision. It's something that I certainly recommend everyone does with their applicants, is to have them enter into an agreement where that is binding and provides some protection to the organization that these valuable pieces of IP, among other things, are going to be protected. The other piece is the trademark protection that we deal with. First of all, there's the people who are claiming to be a PMP, and they put PMP behind their name, put PMP in their job applications, and lo and behold, they're not. Well, one of the easy ways to go back at them is to say you're violating trademark law by using our trademark, our certification mark. There's more the technical term. There's a classification in the trademark register of different classes of trademark, and one would be our certification mark, which permits us to let other people use it in the context of noting that they're certified by us. But if they're not, then it's a trademark violation. And then we have the training companies and testing companies that are trying to, I threw that out, PM program, with the PMP in big, bold, red letters and program down below, hardly legible. We get a lot of those too. And so that's another benefit of trademark protection is against individuals who are, or companies that are trying to dilute our brand and confuse the public by trying to use our well-known marks in the context of their own business.
Bill,
Yeah.
I would guess that usually the first step then is some sort of nastygram from PMI Legal saying stop using our mark.
Politely, we call it a cease and desist letter.
How effective are those? And if they haven't been, have you gone the next step?
Actually, the cease and desist letters are pretty effective. If people realize they've been caught, they usually stop, or at least go into abatement for a while, put it that way. But they go on our search list to see 6 months later, are they still honoring it or not, and it's a mixed bag. But typically the cease and desist letter is effective. Occasionally you get someone who will just not respond to us. And those are the ones who think, well, if we don't say anything, they'll go away. And so we've made it actually a policy. If someone doesn't stop, we have to make it clear to people that we mean business. So if they don't stop, we do go to the next step. We file a lawsuit. There's no instance where we just say, oh, well, Yeah. Some other things we do to help protect the integrity of our certification program. We have a voluntary online register which lists the names and not the total addresses, but the location, general location of people who have passed our certification. And that's very helpful because from two aspects. One is if an employer or a potential employer wants to verify that this person has the certification, they can go and find it. The benefit to us is we get a number of letters on a fairly frequent basis from people saying, or emails saying, John Jones told me, or had in his application from an HR department, had in his application that he's a PMP, but we can't find his name on the register. Can you verify whether he's a PMP or not? And so we have a fairly nice net to catch the offenders in by those kinds of correspondence coming into us. A number of years ago, every once in a while a light bulb goes off in your head and you say, how'd that happen? We were having a lot of our test questions show up on these test sites that sell people exams. and you can go on there and they'll say, we have this exam, that exam, and our exams are showing up. And to be fairly accurate, some of those sites really did have our exams. So it was like, how's that happening? So the light bulb went off in my head one day, and I went down to the certification appointment and said, print me out a list of people who have taken our exam more than twice in a one-year period. And they came back to me. It wasn't the Washington phone book, but it wasn't one page either. And there were people on there who had taken our exams 10 times in a year, 5, 6 times in a year. And you had to assume they weren't taking the exam just to try to pass it if they took it that many times. What they were going in and doing was, to the extent their brain allowed them to, they might be able to memorize 5 or 6 questions at a time. And then they'd take those out, and then they'd add, the next time they came in, 5 or 6 more questions. And then they were selling those questions to these kind of exam prep sites. So we put in a limit that people can only take the exam 2 times a year. And that seemed to help that problem out a lot. With respect to the training companies, one thing that we did is we started since, as I said, PMI doesn't do the training, we started a registered educational provider program. They're known as REPs. And what we did with that was we give them an REP logo. It has PMI in it, but it's an REP logo that they can use. They pay us an annual fee to be a member of the REP program. And they enter into an agreement with us, which includes abiding by certain marketing and trademark guidelines that help protect our marks from misuse. We have over 1,000 REPs, training companies today that are a member of that program. And that has been, I'd say, a pretty useful tool for us to do that. And we've also, as the program matured, we now do an audit of those REPs every 3 years, just to ensure that the quality of their training meets certain standards that have been developed. So it's been beneficial to us. It's been beneficial, I think, to the people who are taking training to know that there's some standard of quality that is being offered to them when they see that the company is a member of the REP program.
Bill, there was a question that came online. What's the information in the registry that someone from the public, if they go to the PMI registry, the PMP registry, is it just the name or is there a location?
There's a general location. It's not an address. I mean, we're trying to be adhere to people's privacy, but it's a general location and a name.
Okay.
Yeah.
If there aren't any questions for Bill right now, go ahead. Yeah.
Well, I had one related.
Wait. No, just a microphone.
Bill,
yeah.
Hello. Katie and I are with ANSI, so thank you for the work you do on our committee.
Pleasure to be a part of it.
We were interested because we run into this too, the misuse of the logo. Do you find your response is different for international misuse versus domestic?
I think the answer is yes. Distance seems to create a perception of protection, and so if you have an ocean between us and them, they feel a little less compelled. But the reality is we've made this policy that if you don't comply, we're going to move ahead. So currently have trademark violation cases pending in China and another one in Nigeria. And recently had one in Lebanon, which they finally settled with us.
Which highlights the need to have good international trademark strategies, because if you are having your designation used outside of the U.S., there are that number of different laws when it comes to how to protect your marks.
Yeah.
Maybe do one more and then real quick.
Hi, Bill. I'd like to know if you get the same privileges when you register copyright outside the U.S. on the secured copyright issue. There is protection in the U.S., but outside the U.S., copyright registration isn't as straightforward.
And that's why I rely on Venable to help me with my copyright protection. Little plug.
The fact that Anita, who asked that question, works for Venable has nothing to do with that.
You're right. Each law is different, but then there's some that have protection because of the Berne Convention, that if it's registered in the United States, it's protected in that country too. So it's not a simple question of one size fits all. You're absolutely right.
Okay, we got one more back here.
With regard to your certification mark and protecting that mark, you mentioned that you in part rely on employers sending you emails saying, hey, I can't find this person on the list. Are there any other mechanisms that you can suggest to enforce that and to be able to combat against, millions of people using it that aren't certified, and then it diminishes your ability to protect it because it almost becomes common?
This won't answer your question, but it'll give you a little flavor. It's a never-ending battle, and given whatever resources you have, you just need to keep attacking it. We have cease and desist letters. I have some paralegals who do nothing but trademark enforcement as their job. We do have a code of conduct. So if someone is a member, and maybe they haven't taken the exam, but if they're a member, their conduct in misusing and misrepresenting themselves could be a complaint that would be brought before our Intellectual Property Committee, which again is another thing that we try to keep as objective as possible so there's no claims of bias by the people that somehow we're picking on them. And so, for example, George is very instrumental in dealing with our Ethics Review Committee, which is our Ethics Compliance Committee. The volunteers on that work with George to manage the cases. I stay completely out of those cases. If there's a case comes up, I'm on the phone with the committee. I drop off the call because I don't want to be in any way biasing those. But that's another mechanism we use for handling some of those.
Okay, just to make sure we have enough time. Oh, okay, go ahead.
When you have an accreditation or certification mark, how do you make the determination as to how you file it? Meaning, do you file it as a certification mark in International Class B, or do you do it as a service in maybe like Class 35 and then license the mark out? How do you make that determination?
It depends a lot on the country. In some countries, filing a certification mark is a never-ending process of taking a long, long time and having to show many, many samples of how it's used. Typically, we don't stop with one category of filing. So we might file it as a certification mark. We might also file it in Class 35 or in another class for publications because we use it in publications as well. So It's really a country-by-country kind of thing. And some countries, you follow in one class what doesn't protect you in any other class. So,
and I know that working with a lot of different associations that have certifications, it's not always here in the U.S. that certification mark is the right mark to go for here in the U.S. Sometimes it's more traditional trademark. Well, at least once a year, Andrew Price will be sitting at this table, who's our colleague who does a lot of trademark work and can talk much more intelligently than I as to when to make that distinction. But I do know that. So I don't want to give any more short shrift to Julie, who's been waiting patiently after a red-eye flight from Phoenix last night. So want to turn it over to Julie and let her talk about AAM and its accreditation program.
Great. Thank you. Just to start out, telling you a little bit about AAM, the American Alliance of Museums. I was in Phoenix for a conference, but we're actually based here in Crystal City. Our mission is to champion museums and nurture excellence in partnership with our membership and our members and our allies. So as you can tell from that, we are a membership organization, a private nonprofit founded in 1906, and we have about 32,000 members, the bulk of which, about 28,000, are individuals, and the 4,000 are institutions. And the majority of them are in the United States, but just because we're called the American Alliance of Museums does not mean we restrict our work within the U.S. We have members from other countries. We have individuals from other countries participate in our services and our programs. So we really see ourselves as serving the museum community anywhere they happen to be. And the core areas that our core areas that help us fulfill our mission are advocacy, thought leadership, nurturing excellence at the individual level through things like professional education and training, career development, and then my area of focus is nurturing institutional excellence, where we come in with standards, ethics, assessments, resources, and the accreditation program. So our accreditation program has been around since 1971, and I think yours started in, your program was 1969, so something was going on around then, because in 1969, actually, there was, it actually emerged out of a presidential study on the industry and museums in general, and it sort of, one of the recommendations that came out of that was to have an accreditation program, and it landed with the, it was the American Association of Museums at that time as the home for that. And, you know, it was really born out of the need to professionalize or sort of turn it into a professionalized profession, sort of an industry, you know, having some standards and having a body that's going to look at them and help advance the field overall. So part of the role of the accreditation program is not just to strengthen individual institutions, but the real goal is to advance the field as a whole and to make sure that we have the opportunity to self-regulate. So there aren't government interventions coming in and doing it for us. For example, there's no official, you don't have to, if you want to be a museum, you can write museum on a sign and stick it out there. There's no process you have to go through in a legal way or through a government agency or anything like that to be designated a museum. Call yourself a museum, you think you are, and therefore we will work with you. In our program, we have, I should also mention that when it was created, we kind of used the educational accreditation system as the general model for that. So today we have 1,054 accredited museums, and just to put that in perspective, that's less than 5% of the sort of U.S. museum population. And so we'll talk a little bit about participation levels and, you know, if that's a high number, if that's a good number or a bad number. We do have one museum outside the U.S. in Australia that opted to come through our program, and we do have one more from Colombia in our program now coming through too. So the international angle is a very new thing for us. So we're trying some different things. And like PMI, we have all of our accredited institutions listed on our website, so you could see who they are and the city and state that they're located in. In terms of resources to run our program, this is sort of entirely different scope and scale. We have only a little over 1,000 museums, and it takes a core of, or a body of 1,500 peer reviewers. Those are the individuals, the volunteer museum professionals that go out and do the site visits. We send 2 people out per review to do a site visit. So we rely on those individuals. They're a core part of the program. It can't operate without them. There are 7 to 9 volunteer accreditation commissioners, that they are the body that's making the ultimate accreditation decisions, and they are a body that's authorized for that role through the AAM bylaws. And they happen to be at our office right now meeting. And have three, including myself, 3 dedicated staff to the accreditation program. I'll give you an overview of our process as well, just in a nutshell. We have a prerequisite step that's called core documents verification. Before you can be eligible to apply for accreditation, you have to send us, we've designated 5 core foundational documents that you have to turn into us, that we review and we vet against a set of required elements. And once those pass, you're eligible to apply, and the application process is a pretty straightforward sort of statement that you're ready to start the process, and a little bit of background information. Once you're through that, you really launch into the heart of it, and you work on a self-study, which is a questionnaire and a series of documents and other materials that you have to submit, and that's currently all online. Used to be all paper. It is online now. After you move through that, and that usually takes that's about a 6-month window of time completion for that. We line up 2 peer reviewers to go out to do the site visits, using the information and data we have on them that they provide about their areas of expertise and their availability and their background and their training and their education, et cetera, in our database. That we have this sort of matching system that can find 2 individuals that are the best choices to go out to do a site visit. They're going to be out there for a couple days, looking at the scope, the comprehensive view of the organization. And then all of those materials, the report that comes out of the site visit, goes to the Accreditation Commission, that they're meeting 3 times a year to make the decision on the organization. They want to accredit them. Do they want to table them for a year to help give them an opportunity to remediate something very practical and very specific, or deny them? And denial happens very, very infrequently. It's usually at that point. They've been given a lot of counsel already at the staff level to, if we can red flag things and give them our best advice that it may not be looking so successful for them, that they usually will leave voluntarily before they get to the commission level. And about 30% of all decisions at each accreditation commission meeting get tabled. The decision's tabled because the museum has some issues. And after the year that they get, about 97% of them, 98, come back and are successful after that. So we have a pretty high success rate. Our program is, I should say, I was interested to know about the whole story about the questions, and your goal is to keep them proprietary. We are completely opposite. Our information and our questionnaire is out there. We want people to have it because we want them to know what they're getting into, and they can work on this material and be prepared so when they come into the process, they move through expediently. So our program is open to all museums of all sizes and types. We don't have we have one program that's for everybody. It's not divvied up or no different standards and no different process for different sizes or different types of organizations. You don't have to be a member of AAM to participate. Fees differ based on your membership level, but you do not have to be a member. And we do have a few minimum operating requirements in terms of hours open, paid staff, that kind of thing, just for minimum eligibility to participate. And most of those are based on capacity there's just certain minimum levels of capacity your organization is going to need to just go through this process. And I would call out, and we get questions about this a lot, is we only only nonprofit entities or museums that are embedded in a government structure, city, state, federal, are eligible to participate. We do not allow for-profit museums in. They're not all that, there's not that many of them, and we get that question a lot. I think eventually we might have to move in that direction, but we've been holding closely to that for quite a long time. And as I mentioned, it's comprehensive. It's all operations are reviewed. And I would say one of the things that we get a lot of questions and confusion about, and I was thinking about this as you were talking about the logo issues. We have a logo for the accredited museum, and the AM logo is part of that. So we see sometimes a lot of institutions are, one, they're just confused about, are they a member? They think if they're a member, they're accredited. And sometimes we happen just by happenstance to come up across a museum on their website, they have the accreditation logo. And often they're just, they're a member of AAM, and they want to put that on their website, so they have gone and just downloaded the logo off, just cut and pasted it off a web page or something like that. Usually, I haven't really found any examples of it being malicious. It's usually just confusion. So we do spend a lot of our time explaining to people that the difference between the two things, as well as it comes up a lot when they pay their fee. I just paid my accreditation fee. It's not my membership fee, that kind of thing. So it's not a huge issue, but we deal with it quite a bit. Okay, so this is going to be sort of, I'm going to say I'm not a lawyer. I have zero legal training or anything like it, so I'm going to rely on my panelists and colleagues here who have the legal training to chime in and maybe kind of add any other angles to sort of balance what I'm saying. I'm really going to focus more on sort of the practical operational issues. There's some really the key factors in the credibility and integrity of an accreditation program come into play with fairness, rigor, and consistency of the evaluation. We heard a little bit about that already today. And that ranges from everything from the procedural steps that we have to how we're actually applying the standards. And of course, if you want to have a credible program, that's important for the sustainability of your the credibility and integrity of your organization that it's associated with. And I should mention that our program is fully embedded in our organization, AAM. It's not, we don't have a separate subsidiary or anything else that's running it. The commission is not a separate body. Everything is embedded within the organization. I know some programs do actually have some kind of separate entity, and sometimes that the commission is overlaps with board members. We don't have any of that. The commission is a separate group, and I'll talk a little bit about how they come about, how they're appointed in a minute. But I'm going to really talk about 3 areas that pose risks to the credibility and integrity of the program based on our experience and my experience. And that's peer review, that's participation, and enforcement. And if you think about enforcement as policing, it's sort of the 3 Ps: peer review, participation, and policing. And of course, there's a lot more, but I was going to focus on 3 here. So the first one is having a peer-based program or using peers. Our program, as I mentioned, is completely dependent on volunteer peers, peer reviewers, to go out and do the site visits, to serve on the commission, to make the decisions. So actually, we've estimated that our peer reviewers make up about the equivalent of 12 to 15 full-time staff members. So if we didn't have them, we'd have to have that in-house resource to do this. But it's an asset and a liability. It's a great asset in the terms of that, this is for the field, by the field. It's not just AM up here making some arbitrary decisions, sort of ivory tower kind of thing. They're from the field, they're your peers, they're the experts, it's a collegial review, that type of thing. However, there are quite a number of issues that you have to deal with when you're working with human beings. you know, we want to have a goal of consistency and quality and accuracy in the evaluation process. But as I said, we cannot, these are people who have day jobs. They come from all walks of life, ages, experience, backgrounds, the types of work that they do, and they're people. And we can only control them to a certain degree. We cannot control them 100%. We have lots of instructions and materials and training, and I can tell you no matter how much you tell them in writing, there's always just the human nature element in all of this process. And ultimately, while we do want to have, as I said, the instructions, try to have as many standardized forms and documents for them to use in terms of the structure of their site visit, the reporting tool that they give back to us. It's sort of oriented as a checklist without a lot of, you know, sort of from scratch type of narrative writing. Unfortunately, it's going to have a subjective aspect to it because they're people. People come with different communication styles, and sometimes these peer reviewers, you know, they don't go out every 3 or 6 months or even sometimes once a year. They're going out. Some go out once a year. Sometimes it might be 2 or 3 years between their assignments. So again, it's a learning curve, and every time they go out for them. So you can't control their behavior entirely, and of course there's a lot at stake because they're out there representing AM. Sometimes there are complaints. There can be complaints about them, and I would have to say they often focus on just the human dynamic, not necessarily intentional bad behavior or professional behavior, though we do sometimes get that feedback. A lot of it tends to come from just different sets of expectations from the museum and the peer reviewer, or some people who just personalities, you know, don't gel. People have different styles, and they don't always mesh with people. We also need to make sure that they're available and they're reliable. And of course, again, they have their day jobs. They're doing this on volunteer time. So we do have to deal with issues of availability and reliability. Will they get that report in? We've had a few every now and then. They're just going to disappear. They're just not going to follow through on their obligation, and we don't really have a stick to do much except saying no more peer review for you. But we have to balance a lot of issues of we don't want to, and we want to have an evaluation program that giving them constructive feedback if there's issues, but not to push them away because we rely on these volunteers and we never seem to have enough. 1,500 might seem like a lot, but that's the pool that we're working with at any given time that we can pull from. So that's one issue that you kind of have to deal with is how do you deal with bad behavior or just not fulfilling your obligations. And we have a potential conflict of interest issues sometimes come up. We do use consultants. They're allowed to be peer reviewers, and sometimes some of them are doing something very similar to what they would do in their day job, and a lot of them tell us they want to do this because it's kind of their pro bono contribution role. And so we want to make sure that we have them. Everybody signs, every peer reviewer has a conflict of interest and disclosure form they're filling out as part of their profile. They don't do it at before every visit, which actually I think would be a better idea. We kind of just do it once or every time they update their profile, they sign off on it. And if you're a consultant, we do set a limit that you can't solicit business within, I think it's 2 years after you do the site visit. So I definitely recommend having really good, conflict of interest statement that they have to agree to, ideally with every assignment, and that sort of business solicitation time frame, and be very clear about what your in writing, publicly on your website, have the criteria for service, the obligations, and obviously you tell them this before they go out every time as well. We do have an application form, so we vet the peer reviewers to some degree. We see their resume, they send an application form, we look at that, and The same with our commissioners. There's a sort of a position description for the commissioners out there, and they actually go through a nominating. There's a field-wide nominating process. That people self-nominate, and then there's a committee that not made up just of the commission to do that. So those are some of the key issues. I think peer review is probably one of the stickiest ones. It has the most legal aspects. So if you want to throw anything in there about that.
I'd say from my perspective, the volunteer aspect makes it a little more difficult because what are you giving them in exchange for this? But it's important to get in writing, as you have, agreements to abide by certain standards, both from behavior perspective, but almost equally, if not more importantly, to make sure they're applying the standards right and that they abide by the conflict of interest and those sorts of things. But particularly if you pay contractors to go out and audit facilities or take a look at products or services that are offered by people who want your accreditation, getting that contract in place with that contractor so that you've got that person to agree to abide by your rules and indemnify the organization and those sorts of things goes a long way, but not nearly as much as good training, good education. A lot of organizations will gather their peer reviewers, whatever you call it, together, as you say, once a year or so often to make sure everyone's on the same page in terms of what's expected and that you're applying the proper standard in a fair way. So a lot of this can sort of fall into the contract realm, and a good contract will help a lot. Obviously, getting releases from the people who are the museums that are subject to the accreditation would be great. They only so they help a lot, but they're not a panacea either. And then the other thing I would say is make sure, for those of you engaged in accreditation, get a good understanding of what your insurance coverage is with regard to those interactions that happen at the site. And make sure if it's not there, get good insurance coverage for those interactions, and maybe they cover those independent contractors or peer reviewers as well. And so that you're not in a situation where if there is some, God forbid, some harm or some loss that's caused, that you go to your insurer and they say, sorry, that's not part of what we cover for you. So those are the things I would add from a legal perspective.
Great. And I know we've got about 5 minutes, so I'll be quick. And I just want to add, the peer reviewers, we reimburse their travel for them. They're not getting any other honorarium or anything like that. The museums ultimately pay for their costs, so we pay the peer reviewers, the museums pay us, so we don't want any direct money going between the museum and the peer reviewer. So it's all clean. I'm just going to jump to enforcement, and if we have time, we'll come back to the participation levels, because I think the enforcement is an important issue. It's important for your program to have enough teeth. That's the term that I hear a lot. They are concerned that the program has enough teeth to be credible, and if my museum is accredited, I want to make sure that there's not other museums out there that aren't up to standard. People look at us to be the museum police a lot. That's what they expect. And sometimes we can be that, and sometimes we want to be that, sometimes we don't. But we have, in some sense, a limited scope of authority. We can only assess the museums on the standards. We don't have the expertise to go out and do sort of legal investigations or get into personnel grievances and issues like that. But we do monitoring by having, I don't think I mentioned this in the process, but you have to go through reaccreditation every 10 years. So that's one way of making sure museums are staying up and with the standards. Our other monitoring, we don't really actively go out there and keeping our eye on all 1,000 museums. If something comes to us in sort of a passive way, or somebody comes to us, we do have probation policies. We have an allegation policy, which somebody could actually file a formal allegation of unprofessional practice, and that is a very complex process where it has due process in it, where it's not anonymous. We don't take anything anonymous. Everybody has to go on record, and it's very transparent about what both parties, the museum and the complainant, are saying and claiming. And, we do see a need for confidentiality, obviously, of the decision-making process and the details and the information that the museums provide. But we want to have transparency, and there's more of a demand for transparency in when are they coming up for review, what's their status, did they get tabled or denied. And we're pretty, we just say if they're on the website, they're accredited. If they're not there, That's pretty much it. We will say the year they were first accredited, if they're still currently accredited, but we don't get into any of the details, and I think that's important for the integrity of the program. So I think it's really important to have for your enforcement that you do have a reaccreditation process, that you have the allegation and probation or sort of punitive in a way, or policies and practices, and that there is due process behind them. And it's very important to define the scope and the purview of what you're looking at. We're very clear. We don't do anything legal. We don't do anything personnel grievances. We get a lot of complaints about, it's usually about people. I don't like what somebody did. I got fired. Unfairness, that type of thing. And it's really important that the commissioners and even the peer reviewers in some sense have to have the guts to take the hard line and withdraw accreditation when it's needed. Because they can't feel bad for their colleagues or something like this. They have to hold their ground, and they do remove accreditation. And we don't put out press releases about it, but they do disappear from the website. And sometimes people do know about it. And I think our program benefits from the multiple perspectives of the staff do an intensive review of the materials, the commission looks at it, the peer reviewers, so you're getting not just one person or one set of people looking at it. And of course, we do want to share information and statistics, so we use aggregate data, and I do think that's important to share information about the program and the participants in an aggregate way.
On that front, it's
yeah?
a great point on enforcement that sometimes gets lost from a legal perspective, because you often think, well, the conservative route is not to remove accreditation or not to remove certification because you're going to tick somebody off. They're going to sue you for some sort of violation of antitrust or something like that. But depending on what you're accrediting or what you're certifying, if you become aware of and you have actual knowledge of an entity doing something wrong and contrary to your standards, or you become aware of a person who holds a certification doing something that's clearly contrary to your standards, that's where that tort liability that we talked about earlier could actually come into play. The actual awareness that the organization has, once you have that awareness, it's very hard to defend a case. While the general rule is there's no duty to third parties, where you have taken on the role of a certifier or an accreditor and you don't do your job and you're negligent in that way, you're in trouble. So from a legal perspective, it may seem as though the safe route is to let them slide. Mm-hmm. Oftentimes it's not.
Right, and we do have museums that come back for reaccreditation and they just haven't kept up and advanced. And oftentimes the peer reviewers, I would say one thing on the peer reviewers, and it's sort of tied to enforcement, is their colleagues, they're in the same circle, right? So they have to balance out their own personal relationship and professional relationships with these museums. So sometimes they're reticent about kind of taking a hard line or being too tough, and they'll put a lot of information in the report. It's like, oh, here's all these problems. Oh, but in the end, we think this is a great institution to be accredited. So there's sometimes a lot of sort of misalignment in that.
And that's another point that comes up, particularly with associations. Associations are oftentimes small clubs, and people know people, and even with a big organization like PMI, people on a committee who are accrediting, people who are on a committee who are investigating someone's ethical behavior, those sorts of things, they may know a name, they may have encountered a person. It's important for those people to understand what the rules are and what we're going to apply with regard to conflict of interest, because the sheer practicality of it is, if you were to recuse yourself from every decision because you happen to know somebody in an association, very often you'll have a lot of recusals and a very difficult time getting your job done. So it should be, obvious if there's a business interest, if there's a family interest. I mean, there's obvious situations, but the rules should be clear to everyone participating. Here's where we'll say you've got to recuse yourself. And so it's a practical point more than a legal one, I think.
Right.
You could have people sitting out every decision.
Exactly. And the commissioners are really good about that, and we do, in fact, let the museum see a list of potential people who might visit them. We do the final selection, but they have the opportunity to identify any conflict of interest, relationships we wouldn't know about. So, on time, do you want me to just say a couple words about the last
sure, go
piece?
ahead.
Okay.
Take a couple minutes there.
Okay. Go back to this. Just on the level of participation, we are less than, I mentioned we're less than 5% of sort of a penetration rate in the field. And some people say that, it's good, keep it, an exclusive, I don't want to use the word club, but exclusive group, high standards. The tagline used to be a higher standard. So it was the expectation that you're not just meeting the standards, but you're going above them. And so there's been a lot of conversation we've been having about, should it be the other way around, that it's about the sort of minimum standards, which when we want more museums to be able to be accredited and embracing the standards and professionalizing, not to keep it out here and kind of scare people away about the process or anything like that. When do we tip the balance from it becomes the exception to be accredited to be the exception to not be accredited. So it's kind of one thing we're struggling with now. But to look at your program, you need to have enough participation that it's meaningful, it's having impact, it's having it's representative of the field. It's not just a small slice and type of it. In our range, we do have everything from the Metropolitan Museum of Art to a very, one-person staff historical society in a rural area. So we really have the breadth of it. The program needs to be, you have to look at accessibility, not like ADA accessibility, but sort of accessibility in terms of it being relevant and applicable and affordable, and it's not taking the process isn't putting so much burden on the institution that it can't do that. And we actually spent the last few years what we called streamlining the program and the process and really taking a hard look to go back to basics, because the process was actually being too burdensome and starting to overwhelm the value, and people were questioning the return on investment for it. So that's one thing you have to be very careful with. What's your value proposition? What's your return on investment? We can't measure it in dollars, actually, but being able to articulate that, thinking about the burden of the process, thinking about the cost and what your stakeholders and your market is going to bear. That's always a very challenging, delicate situation when it comes to costs. And all of that, you want to maintain the rigor of the program. When we did this reinvention the past few years, we just kind of relaunched a couple years ago. People told us in all of our surveys, all of our focus groups, everything, no accreditation light. We don't want different standards and different processes and different things for different types of organizations. So that was very important, is to maintain the rigor regardless and make it equitable for everybody. Everybody's going to wind up at those standards in a slightly different way, but they have the same process and the same expectations. And so, great. So that's a little bit on participation levels. So, yep.
Well, I know we've run a little bit over, and I know I'll be able to stick around for a little bit longer, and Bill might have a train to catch soon, but may have a few minutes. But
I can stick around.
Please join me in thanking our panelists for a very informative program.